unprecedented exercise of power under that clause. And even judges ruling for the federal government are saying this is an unprecedented exercise of power, of authority. And obviously it is Virginia's position that it goes beyond what the Constitution allows. You can go back past the Constitution, you can go back past 1776, go back into the era before the Revolutionary War, the 10 years before we were boycotting British goods, starting with the Stamp Act in 1765. And that carried on all the way up to the Revolutionary War. And at that time, the King's Attorney General and Solicitor General, by tradition, sat in Parliament. And they were asked during this period in the late 1760s whether the boycott of British goods by colonists was treason. And the answer was close, but no. That the colonists are within their rights, but not treasonous. Now flip that coin over. What that means is that King George III's Parliament and his lawyer, and presumably the king, because he didn't try to undo this, recognized that they could not compel American colonists to buy British goods. But we have a president and had a Congress who think they can. And as noted, there is broad disagreement on what any particular part of the Constitution means. However, it seems reasonable for all Americans to be able to agree that we fought a Revolutionary War to establish government that was less powerful than the one we were leaving. That was, in fact, the point, put one way. So the Venn diagram looks like a donut. The king's government, the bigger circle, and not colonial government, but the American government as the inside circle. The exercise of this power to compel Americans to buy a product from other Americans is sufficiently unprecedented and goes beyond anything King George III claimed or the Parliament of Great Britain. It would actually be a power more expansive than any they exercised in the economic arena. The federal I'll take questions at the end. Our argument is that the federal government may not use the Commerce Clause, which allows it to regulate commerce, to compel you into commerce. And again, that has never happened before. Under the guise of regulating commerce, the federal government has never ordered people to buy a product, ever. And as I mentioned, didn't even happen in the colonial period. They can tax you. That's what happens with Medicare. We all pay 2.9%, soon to rise for some people, of our income. Goes to the federal government. They use that money to pay for Medicare. That's done under the taxing power. It's a broad power. It's not an unlimited power. But that's how Medicare and that's how Social Security are conducted. The federal government argues that our decision, an individual citizen's decision to do nothing, not to buy health insurance, to take no action whatsoever, is in fact economic activity. So in their dictionary, inactivity equals activity. And the phrase economic activity is important to the lawyers because that's what shows up in all of the case law related to the Commerce Clause. So they are arguing that deciding to do nothing is economic activity. One judge in the District of Columbia who ruled for the federal government, I think, properly described what the federal government is attempting to regulate. And her phrase was mental activity. The federal government is regulating your mental activity. George Orwell would be very pleased. He could write a sequel. The power, if this exists, if it's allowed to stand, would be an extraordinary and nearly unlimited power to order you to buy anything for any reason Congress thought was a good reason. That's why we tell people that this lawsuit is about liberty, not health care. Because you can take health care out of this and put automobiles in, you can put asparagus in, you can put gym memberships in, and the legal principles and the principles of power and authority of the federal government are the same. They are the same. So 100 years from now, what's going to matter is not how this roiled our healthcare market, It's going to be whether or not the federal government has this extraordinary power that they can order you to buy a whole bunch of other things or not. In May, we argued before the Fourth Circuit, and 9 days ago or so, the Fourth Circuit decided that Virginia didn't even have standing to bring the case. Now, standing is a legal term that means you have to be injured in some way to even get a ruling from the court. So they didn't even reach the merits of the case. Now, set aside the healthcare case for a moment. They are the only appellate court in the history of the United States of America to ever not let a state defend its own code of laws. Now, a lot of the states in the Florida case do not have laws that directly address whether or not you can or must buy health insurance. Virginia does. Virginia has exercised its sovereign authority to regulate in this area. And what we have said, our General Assembly said about 2 weeks before the President signed the federal health care bill, is that no Virginian can be ordered to buy health insurance against their will. That means your employers can't order you to buy it. Now, you all are actually the exception. We carved out universities as an exception. So as students, I suspect you all, as a condition of enrolling, were required to either have or obtain health insurance because the university presumably doesn't want to end up having to deal with that. And so that was a carve-out, and that is within the authority of the state to do. But everybody else can't be ordered by an employer, by local government, by the state government to buy health insurance as a condition of employment. So there's a question of whether the federal law would preempt the state law. Of course, the Supremacy Clause says federal laws trump state laws. But the Supremacy Clause has a presumption in it itself, and that is that the federal law is constitutional. And so that conflict, where the federal law would normally trump state law, is an injury. It's just one the Constitution normally allows to take place with no remedy. That's how we make federal laws superior to state laws, the Supremacy Clause. The Court of Appeals, in their ruling, made some extraordinary statements. The most extraordinary was that if Virginia was allowed to bring a lawsuit like this, that it could lead to the states being, quote, constitutional watchdogs, unquote, over the federal government. The judge's conclusion is 180 degrees from the founding vision of the role of states. States are supposed to be constitutional watchdogs over the federal government, just as the federal government is supposed to be a constitutional watchdog over the states. It goes in both directions. That's how the founders set up our government. That's what federalism is. There's no other appellate court, as I said, that has ever denied in any type of case a state's ability to defend its own code of laws. It's unprecedented. And so that ruling has set up what may be one of the biggest federalism cases in the last 200 years. We are appealing to the U.S. Supreme Court. Presumably we'll file that this month. It is going to take another year or so for this to work itself out. The Sixth Circuit, which out of Cincinnati has a case that has gone up. The 26 other states out of Florida have one in Atlanta and the 11th Circuit. So all these cases are going to come crashing together in the Supreme Court. That's a constitutional example of federalism. The federal government is also breaking the law, its own law, federal law. Even before the health care suit, the EPA was another front in Virginia's fight for federalism. In December of 2009, before I was sworn in, but after I was elected, EPA declared CO2 and 5 other greenhouse gases as dangerous to human health because of their role in global warming. This is the same CO2, of course, that we're all exhaling, you horrible polluters, you. Since Congress, not so much since Congress wouldn't pass cap and trade, but the greenhouse gas endangerment finding, the way it works is you have an endangerment finding and below it come regulations. The endangerment finding establishes the authority to promulgate the regulations. The regulations EPA has in mind essentially would do the same thing as cap and trade would have had it passed through Congress. It hits the same industries on a similar time frame. with similar economic impacts and the same economic devastation, especially to the poorest parts of Virginia. Unfortunately, the EPA doesn't really care about economic impacts. As the administrator said to Politico last year, economic consequences aren't my job, quote, unquote. But that isn't what's critical for me as an Attorney General. What's critical for me as an Attorney General is this particular endangerment finding they obtained in violation of the law. They did not follow their own laws to do this. They delegated their research authority through the UN to the IPCC rather than doing their own. Now, regulatory agencies have lots of authority to do this stuff, but not to delegate that authority again. And what that means for a lawyer who's dealing with the legality of the regulation is, let's say I want to subpoena something related to the formation of this particular rule. Well, I can subpoena the EPA, but I can't subpoena some university in East Anglia. I don't have any reach over there, and nor does anyone else in the U.S. The EPA relied on data from scientists, some of whom were shown in the ClimateGate emails to have been manipulating and destroying data in ways that was supportive of the outcome they wanted, though couldn't demonstrate with a level of certainty that compelled people to go forward. Even some of their own who were more concerned about the loss of credibility to science, such as Judith Curry at Georgia Tech, have noted that what these folks did was clearly manipulative. It clearly left the realm of objective science, and that they clearly deleted data that was adverse to the conclusions they wanted. And so what we did was we did two things at once. We sued the EPA because this is all in violation of the law. And we also petitioned them directly, not with the court, but asking them to reopen their own record and simply take in all this other information and then make another decision on their own using their own discretion to do that. They took 6 months to issue a 360-page rejection of our petition, and our petition was essentially that there's new evidence since your public comment period closed that you should hear. And in their 360 pages explaining why they didn't need to hear new evidence, they cited over 50 new pieces of evidence to explain to us why new evidence wasn't needed. You know, you can't make some of this stuff up. It's so outrageous. The other agencies are acting similarly that have an impact on Virginia. The OSM, which most people north and east of Roanoke had never heard of until recently, the Office of Surface Mining, 1/3 of Virginia's coal mines are surface